Hello, and welcome to Connected with Latham, where we discuss ideas, legal developments, and business trends shaping the global economy. I'm Beatrice Lo, an M&A partner in Latham's London office. In this episode, we discuss how buyers can address issues discovered post-closing with their newly acquired businesses. This is a trend we're seeing as a result of the buoyant M&A market in 21 and 22, where we saw deals signed with shortened due diligence processes and much fewer contractual protections for buyers. So with me today to discuss the options available to buyers facing post-closing discoveries are Nell Perks, a partner in our litigation team, and also Leah Adeniran, an associate in our M&A team. Nell and Leah, welcome to the podcast.
It's lovely to be here. Thank you, Beatrice.
Thanks for having us, Beatrice.
So, we all remember the M&A surge in 21 and 22, where deal timelines were compressed, and that led to many deals being signed with fewer buyer protections and less information about the target companies relative to previous calmer cycles. Nell, what are you now seeing in the aftermath of that M&A surge?
Well, we've seen a real rise in post-closing discoveries of issues in target companies, and as a result, an increase in M&A disputes, leading to more claims and litigation. And this has really been compounded by ongoing macroeconomic and geopolitical challenges that have arisen. A buyer's best defence against the discovery of issues in a target is always going to be rigorous pre-closing due diligence informed by expertise. So absolutely making sure that you have the right people asking the right questions to identify any issues is key, and also careful negotiation of buyer protections in deal documents. However, that's not to say that acquirers who are now suffering from buyer's remorse are not without options. M&A litigation, including claims available under deal documents, is prevalent. And where deal protections are limited, we are also seeing buyers looking to other avenues, such as claims under warranty and indemnity insurance policies, or people bringing claims citing fraud. And as part of this overall, we're seeing a growing number of detailed post-closing reviews of acquired businesses. And this can really prove a valuable exercise as a way of preempting issues and implementing improvements going forward.
Interesting. So let's talk a bit more about the dispute side of things and claims. Leah, do you have any thoughts as to lessons that can be learned from that?
Yeah, so as you mentioned, Beatrice, record levels of M&A activity in highly competitive deal processes, they've resulted in more seller-friendly deal terms with things like tighter financial liability caps, shortened periods for claims, limited seller recourse, and also resistance to other protections like escrows and material adverse change or MAC clauses, to name a few. We've been hearing about recent claims and disputes that allege breaches of warranties, particularly those involving financial and operational issues. So this really extends beyond common areas of disputes like purchase price adjustments and earnouts. We're also seeing that other recent warranty breaches claimed by buyers relate to things like non-disclosure of litigation and tax liabilities, and also failure to notify buyers of upcoming regulatory action in regulated sectors.
Interesting. I think, at least in my experience, it's becoming increasingly common, though, for buyers to take out transactional risk insurance policies, so things like warranty and indemnity insurance and tax insurance. And so in those circumstances, when we're talking about claims, we're really talking about claims buyers have against their insurance rather than against the seller. Do you think we're seeing more of those sorts of claims as well?
Absolutely. Insurance brokers have actually been reporting that in the first half of this year, they've seen a significant increase in claim activities, with notifications rising by, I think, almost 70% compared to 2022. Among the most commonly reported claims under W&I policies are for financial statement breaches. However, in our Latham private M&A market study, only about a third of buyers actually take out insurance policies. And lacking an insurance policy can leave limited options if deal documents restrict seller recourse.
Yeah, so that's definitely something to think about for buyers when they're doing deals. Let's move on then to circumstances where issues arise from lack of disclosures. As we know, under English law, the general principle is that of caveat emptor, that is, let the buyer beware. And so that means that there's actually only a limited duty on sellers to disclose issues. Now, how have you seen this affect the prevalence of claims of fraud in the M&A context?
So instances of fraud being alleged in the context of acquisitions are not uncommon, but they are rarer because of the comparatively high barrier to establish fraud. Where you see them, they can be allegations of artificial inflation of reported revenues or revenue growth and gross margins or other kind of distortions. And I think it's worth remembering that fraud claims can encompass both allegations of fraudulent activity within a target company that's detected after closing, as well as buyers claiming that they were fraudulently induced into buying the target by the seller. The difficulty with fraud is it's hard to spot and can be even more difficult to prove, but it is worth looking for because fraud within a target company can very quickly lower the value of an M&A deal, particularly where there may be fines and penalties for associated wrongdoing.
Right, but given that it's so difficult to discover fraud and then establish that fraud has taken place, why would a buyer pursue that type of claim rather than just a simple claim for breach of warranty?
Yeah, so there are a few reasons. The first is discovery of a fraud between signing and closing will usually give right to an immediate right to terminate the SPA, at least if it's sufficiently material. So that's a really important way. And then after the deal is closed, if there is fraudulent wrongdoing discovered, there may be two key reasons for claiming in fraud rather than for a breach of warranty. The first is the remedies that are available for fraudulent misrepresentation. This will involve rescission of the contract, so a full unwinding of the contract to put the parties back in the position they were before the transaction took place, and also tortious damages where there's no limitation based on the remoteness of loss from the purported fraud. So whereas the principal remedy for breach of contract is contractual damages, and this is subject to a remoteness test that's intended to put the parties in the position they would have been in had the contract been performed, misrepresentation and fraud results in an unwinding. And the second reason is that a seller can't contractually exclude or limit liability for fraud via exclusion or limitation clauses. So any attempts to do so in English law will be ineffective. As the saying goes, fraud unravels all. On that point, deal teams should note that the approach taken to fraud does vary by jurisdiction, and some jurisdictions may allow for non-reliance clauses to exclude liability for fraud if they're drafted with a sufficient degree of explicitness. But generally, case law in other jurisdictions is fluid and fact-specific. So really, in any case, if fraud is suspected post-closing, buyers should seek legal advice as soon as possible.
That all makes sense. So I think actually the lesson to be learned from all of that is going back to the first point you mentioned, Nell, at the beginning, is actually the importance of conducting robust due diligence right from the start. So, Leah, what are your thoughts on how both buyers and sellers could prepare for that in advance?
Well, as deal activity has slowed since the second half of 2022, many buyers have actually undertaken more extensive DD exercises. These exercises include things like forensic scrutiny of financial information, as market valuations have declined, particularly in the tech sector. So, in terms of what buyers and sellers can do to prepare in advance, I'd say, firstly, deal teams should work closely with their internal and external advisors and support ongoing discussions between each of them. This encourages things like critical cross-practice information flows for overlapping issues such as regulatory, employment, tax, and finance matters. Another thing, advisors should also look to bring in expertise from specialisms such as data privacy and cybersecurity. And litigators, they should be conducting pre-signing review of key deal terms. This includes careful negotiation of acquisition agreement language, including things like warranties and indemnification provisions, as well as post-closing mechanics. Boilerplate provisions and dispute resolution methods are often more important than is appreciated. And, particularly in that pre-signing run-up when everyone is trying to get the deal over the line, they can often go overlooked.
Right. But then what about after closing? Now, are there any post-closing best practices you would suggest to mitigate against potentially bigger issues or regulatory inquiries later on?
Yeah, and I think we're increasingly seeing acquirers conducting post-closing deep dive reviews into target companies, and these can be really valuable. We'd suggest that acquirers should perform a rigorous risk assessment of internal controls, policies and procedures, as well as probing transaction level data to identify any anomalies and risks. And these really should now be part of the ordinary course for acquirers. Additionally, conducting a cultural review internally or with external advisors may be appropriate, particularly if the initial assessment has identified that there may be culture-related issues. When doing these sorts of exercises, engaging external lawyers to assist can ensure that an accurate picture is obtained, and it may have the added benefit of making the product of any review privileged. The sorts of reviews we'd recommend include analysis of non-data sources as well, such as staff interviews, exit interviews with departing employees, and review and promotion of whistleblowing hotlines and channels to encourage a proper flow of information. Acquirers should take steps to compare financial information pre- and post-closing to identify any significant changes, and they should also conduct a thorough compliance program assessment. This will include considering the target's approach to anti-bribery and corruption issues, procurement, finance, and compliance. And as I mentioned, consideration of culture issues post-closing is really important. As part of this, buyers should look to use their own robust governance and compliance programs to integrate the culture of the target company's operations. And this kind of analysis can really minimize the chances of inheriting major issues, and where there are issues, making sure they're nipped in the bud. It's also just a critical and very useful time for companies to consider and monitor their own cultural trajectory by designing and implementing a culture framework and strategy. And holistically, these kind of steps can facilitate a more positive culture and reduce the risk of issues arising going forward.
Well, thank you. That's super interesting. And I think our discussion really shows that there are a wide range of arsenal of tools at buyers' disposals to combat any potential buyer's remorse in M&A. Now, Leah, thank you so much for your insights today.
Thanks very much, Beatrice.
Thanks, Beatrice. This has been fun.
And thank you for listening to this episode in our Connected with Latham podcast series. You can subscribe and listen to new and archived episodes of Latham's podcasts on lw.com, Apple Podcasts, Google Podcasts, Spotify, or wherever you normally get your podcasts. If you would like more information about the topics we've discussed here today, please do email us from the links located in the show description. We hope you'll join us again next time. Thanks very much.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins LLP, 1271 Avenue of the Americas, New York, New York, 10020. Phone number 1-212-906-1200.